Good afternoon, all of you. Are you able to
Afternoon.
see the screen?
Yeah, ma'am.
Is it visible?
Yes, yes.
Yes, ma'am.
Okay. Okay. So let's start. Let's start for today's session. And today's session is day 2 of our Bharatiya Nyaya Sanhita. And today I'll be discussing with you all chapter 6 to chapter 12. Now, before I move to chapter 6, let's do a recap of what we did yesterday. Yesterday, we started with introduction to Bharatiya Nyaya Sanhita. From chapter introduction plus chapter 1 to chapter 5, we have discussed. And while discussing introduction, while going through these chapters 1 to 5, we understand that BNS has, brought in a lot of reforms, a robust legal framework, which was much required for our evolving society. The most important thing is it's about gender neutrality. The definition of a child, it's given in section 2 of BNS, which says that any person who is below the age of 18 is child for the purpose of BNS. Transgender, they have been recognized. The definition includes the definition of the transgender in section 2, which is again a very relevant addition to BNS. Transgender being a citizen, even they have certain rights and certain duties, right? The legal provisions for their safeguard was much needed. Earlier, there was, offenses do happen with the transgender, but then they do not have any scope where to go for the remedy. So section 2 says that he, the pronoun he, will be used for girl, boy, male, female, and transgender. A very nice reformative change in PNS. New form of punishment. Initially in IPC, there were 5 types of punishment. A new form of punishment has been added, which is based on the US criminology. Now, this is community service. See, BNS has tried to maintain the balance between the rehabilitation and deterrence. Deterrence is there in, where there are punishments, because number of offenses in BNS are same as taken from the IPC, just there is an enhancement in the punishment, be in the imprisonment or be it the fine. But this new concept of community service, it has been added. This has been added for the petty organized crimes. For the first-time offenders, depending on their circumstance, situations under which the person has to, commit such offense. Now, there is no definition of community service given in BNS, but yes, the mention of BNS, the mention of community service is given in BNSS, which has replaced the Criminal Procedure Code. Explanation to Section 23 of BNSS. Still, it is open to the discretion of the court to decide what kind of punishment pertaining to community service will be given to the offender, to the victim. Now, this can be to work as a gardener or to stand at the traffic junction to maintain the traffic. So it can be anything depending on the nature of offense depending on the discretion of the court. New form of punishment, which is with the concept of rehabilitation. Changes in section. So it's very relevant. In IPC, there were 111 sections, 23 chapters. Now in BNS, we have 20 chapters and 358 sections. Then does it mean that this much of, the gap, 511 and 358, so these sections in between, are they being deleted? No, they are not deleted. If you remember in IPC from section 2 to section 45, it was all about the definition. Now what they have done is they have clubbed all the definition together and they have placed it within section 2 of the BNS to maintain the simplification, to maintain the clarity. Now all the acts, all the offenses pertaining to the similar nature, they have been kept together in one section. Just to make it simplify, it's easy to understand. Clarity is there. So this is done for this purpose. There are sections which have been clubbed together. Hence, there is reduction in the sections. New offenses. Organized crime, petty organized crimes. All these have been recognized as a new offenses. Cyber crimes. Earlier, there in IPC, there were no mention of the, electronic records, digital medium. But now they have been recognized in BNS. The document, the definition of document does not merely mean the physical document. It means the electronic document as well. So yes, with the advancement in technology, with the reform and with the new law, all these provisions have been taken care in BNS. Now moving to chapter 6, which is about yes. Chapter 6 of offenses affecting the human body. Thus, there has been no change to the understanding of culpable homicide. Section 299 of IPC has been taken as it is. The definition of murder, the offense, the ingredients pertaining to the murder, the punishment for the murder is same as in 300 IPC. It's just that the number of section has changed, which is now 101 BNS, which talks about murder. Section 103, a new provision has been added. New provision pertaining to mob lynching. Now, mob lynching or mob violence, if we just go a little back and we see the Manipur incident on the basis of the community. So there has been judicial pronouncement on these even before. In fact, Manipur Protection from Mob Violence Ordinance 2018, Rajasthan Protection from Lynching Bill 2019 already were there in the state legislation. But then this mob lynching is not subject to only in a state. Tehseen Poonawalla versus Union of India 2018, this landmark judgment by the Supreme Court, it addressed the rising incidents of mob lynching. So in this case, the court has provided several guidelines how to prevent mob violence, what actions can be taken, as in the establishment of fast track trial, victim compensation, preventive measures, as in to appoint the nodal officers. We all have right to speech, right to expression. But the entertainment industry, the media, they often face this mob violence pertaining to any film or pertaining to any article, pertaining to any picture. So this, again, it is hampering the fundamental right of an individual. Now, this was given in the case of Kadu Galar Film Society versus Union of India in 2018. National Campaign Against Torture Cases. Number of PILs have been filed within this National Campaign Against Torture Cases. And this have highlighted the mob lynching, the mob violence, as well as the custodial death. So, when this National Campaign Against Torture Cases were being heard, this called for a legislative reform to protect human rights, to protect human body. Muhammad Harun versus Union of India 2019. In this case, the Supreme Court had given direction to the central and the state government to take measures against the issues, against the incidents of the mob lynching. The court said that there must be some adequate protection given to these vulnerable sections community. Hence, taking the recognition of the judicial pronouncements, this mob lynching has been added in the BNS, and the punishment to it is, it can be a death punishment, imprisonment for life, and shall also be liable to fine. See, when we discussed about the community service, then I told you about the rehabilitative approach of the BNS. Now, when you read or understand this section 103 clause 2, it is a deterrent provision. So BNS has tried to maintain the balance between rehabilitation as well as the deterrence. The society where we are, living, if rehabilitation is required, then there is a requirement of deterrence as well. So to give effect to this new provision of 103 clause 2 about mob lynching has been added in chapter 6. Yes, causing death by negligence. This was there in the IPC as well in the section 104A. Am I audible to all?
Yes, madam.
Okay. So this was there in section 304A, but a little alteration has been done here. Now, by alteration, it means that even the registered medical practitioners, if they are rash, if they are negligent while they are performing any medical procedure, even they will be punished with imprisonment. Now here, for the purpose to understand the registered medical practitioner, the explanation is that such medical practitioner who has this practitioner certificate recognized under National Medical Commission Act 2019. Now, for instance, I'll just give you one example.
I have a question here. What about
I'll take
yeah.
the questions at the end. Okay. Is it clear? I'll take the all the queries I'll take at the end. So just an incident, example I'll give you. During any medical procedure, what is the intention of a doctor? The intention is to save, to cure the person. Okay. Now suppose during any such medical procedure where there is a negligence by the doctor, by this medical practitioner, and the death of a person happens. And another scenario where there was, due diligence was maintained, but still the person could not survive. Then will the medical practitioner be held in both the cases? No. Where the due diligence was maintained, still the person could not survive. There the medical practitioner cannot be held for the rash or the negligent act. But where there was negligence pertaining to the diligence, then yes, the medical negligence, the medical practitioner will be held. Now, again, there was, this was not accepted by Indian Medical Association. They have challenged the BNS. But if you see the practically, if you see the incidents that are happening or that have happened in the past also, there are victims of medical negligence. So this BNS has again taken the recognition of this offense in our evolving dynamic society. And it has just altered this section of 100.4A in 100.6 of BNS. Accident because of rash and negligent driving. So many examples in recent times, right? Pune incident, hit and run cases. Now again, here, the intention of a person is not to kill the person. Driver does not have any intention which can be called amounting to culpable homicide. So what is given in your in this clause 2 is that if the road accident happens because of negligent driving or rash driving, and if the person, he reports it to the nearest police station, police officer, if he reports it to the magistrate soon after the accident, provides for the medical assistance to the victim, then his punishment can be reduced to community service as well. But if he fails to do any of these, then under such situation, he will be punished for the term which can extend to 10 years and shall also be liable for the fine. So you can see in this clause, subclause 2, that if there is a rehabilitative motion, then there is a deterrent as well. So the person who has committed such offense, the responsibility is on him to report it to the police as well as to provide for the medical assistance. Then his punishment can be reduced. There was the use of the term insane in 107, which was 105 of IPC. Now, this term insane, it has been replaced by the term unsound mind. Insane, lunatic, these were the term which was used during the, colonial period, and till long it has been used. The thing was that insanity of a person was considered as a taboo. So people would not come to take this as a defense. But with our dynamic society, with the change in the mindset, with the evolving, medically we are evolving, technologically we are evolving. So we are in an era where the unsoundness of mind is taken as mental illness. No more a taboo. It is talked about. We have Mental Illness Act. We have Disabilities Act, which all recognizes the unsoundness of the mind. So yes, the term insane, lunatic have been replaced throughout the BNS with the term unsound mind. 100-3 IPC. You all are able to see the slides, right?
Yes, ma'am.
109 IPC. Attempt to commit suicide. Now, this provision of IPC has been deleted. Reason being, attempt to commit suicide is taken as a mental illness. The person is not mentally stable. He needs assistance, not the punishment. Hence, this clause, the section 309 IPC, has been deleted because there is no requirement for the person to, it will be the fear, or it will more threaten the person. He might be under some dogma for which he has taken such step, and again a deterrent punishment for him. The person might not escape the fear of it. So this has been deleted, and this has been deleted for a good only. New provisions. New provisions pertaining to organized crime, petty organized crime, and terrorist act. Now, organized crime, this is in alignment with the Maharashtra Control of Organized Crime Act, MACOCA. Now, which after 1999 hit hard crime syndicates in Mumbai, Maharashtra, state enacted this legislation. And on the basis of MACOCA, different states, they have also the state legislation concerning the organized crime. Now, what is organized crime? Now, unlawful activities conducted by highly structured and sophisticated criminal group or organization. For example, kidnapping, robbery, vehicle theft, extortion, money laundering, corruption. All this is an organized crime. Continuous, how it's defined? Organized crime syndicate means a group of 2 or more people who, acting either singly or jointly as in syndicate or gang, indulge in any continuing unlawful activity. Very structured and very experienced persons. Trafficking, human trafficking, animal trafficking, drugs. Now, endangered animals, they are being trafficked for the precious their body parts. Petty organized crimes. Recently, the NEET paper leakage, the NET paper, UGC NET paper. Now, all these have been recognized as a petty organized crime. So, petty organized crimes are basically, because the question might come, organized crime and petty organized crime. What is the difference? The difference is that petty organized crimes, they are subject to a particular geographic area. Criminal offenses, criminal activity of less severe nature. A smaller group, less sophisticated activities. For example, snatching, paper leakage, unauthorized betting, gambling, small theft. Now, for the first time, snatching is also used in the BNS. Earlier, snatching was an offense which was penalized under robbery. But now there is a separate provision for snatching. The term snatching has been used in the BNS. Terrorist act. Now, this terrorist act is a very violent or a threat of violence designed to instill fear, coerce, intimidate government, society, specific population to achieve any political, ideological, or religious goal. The definition of this terrorist act is given in Unlawful Activities Prevention Act, which is already a law in India, aimed at preventing unlawful activities and addressing terrorism-related offenses. But since the addition is made, it gets more value, the added importance to the Terrorist Act. It gets more deterrent. That if by any of this act, anybody tries to threaten the unity, integrity, security, or economic security of India. So kind of the financial fraud we have been facing. So it has been recognized the economic security is also taken care in the BNS. Yes. So most of the articles, for instance, if you see this section 116H about the grievous hurt, which was earlier 321, 323, 322, 325. Now they all are clubbed together into one section. Now 116H, it gives a definition of grievous hurt. What is grievous hurt? So this addition is there. This was, provision is altered within 320 of the IPC, where the term used was, instead of 15 days, it was 20 days. So any hurt which endangers life or which causes the sufferer to be during the space of 20 days in severe bodily pain or unable to follow his ordinary pursuit. This was in the 320 IPC. Now this 20 days is replaced by 15 days. So now it's any person which endangers life or which causes a sufferer to be during the space of this 15 days. It is also within the definition of grievous hurt. Section 117. The sections pertaining to this grievous hurt, they had been clubbed like 324, 326, they are clubbed to form 118. The provisions of 117 also 322, 325, they have been clubbed together to form the part of 117 clause 1 and clause 2. The clause 3 and clause 4 217, they are new subsections. Where if the injury, if the grievous hurt is so, the commission is so that a person is suffering from permanent disability, or if he is in persistent vegetative state, then the offender will be punished with rigorous imprisonment for the term which is not less than 10 years. And this can increase to imprisonment for life, which shall mean imprisonment for the remainder of that person's natural life. See, in IPC, the understanding was that if it's the imprisonment for life, it means 14 years. But in BNS, this is again changed. This is modified. It means if life imprisonment is there, it means the imprisonment for remainder of that person's natural life. Unless and until it is mentioned by the court whether such imprisonment is for 14 years, 16 years, or 20 years. Now, again, this is open to the discretion of the court, depending on the nature of the crime, depending whether the person is the first-time offender, how much the victim has suffered. Is it clear? So this is what will mean for the imprisonment of life. And if any person, the grievous hurt is so that, permanent disability is being faced, then yes, the offender is liable for the punishment not less than 10 years, and which may extend to imprisonment for life. Clause 4 is added where a group of people, if they cause the grievous hurt to any person on the ground of race, caste, community, sex, place of birth, language, personal belief, or any other similar ground, then the person will be, each of the member of that group will be guilty of the offense of causing grievous hurt. Now, yes, we do hear about the communal rights. We do hear about the issues of the caste, race. There are offenses pertaining to the personal belief where there is a, the offense is there, the hurt is there. So now the BNS has taken recognition of that also, and the person will be punished if the burden of proof, if it's proved in the court, the burden of proof obviously lies on the victim. Rest all the sections regard pertaining to this voluntary causing harm, 332, 333, it has been clubbed into 121 BNS. No changes. 328 IPC, it has been taken as it is into 123 of BNS. Majorly the sections pertaining to this chapter 6, they are clubbed together where there's grievous hurt, negligence. The punishments have been increased where the punishment for assault or criminal force otherwise than on a grave provocation where it was 500 rupees 500 in IPC, it has now increased to 1000. Where the punishment was 1000, the punishment has increased to 5000. Wherever the punishment was 200, the punishment has increased to 1000 rupees. So yes, there is increase in the punishment, be it imprisonment or be it fine. Now in section 137, 361 of the IPC, 16-year male and 18-year-old female was used. Now for the purpose of gender neutrality, the term used in the section 137, which is similar to section 361 of the IPC, child is used to maintain the gender neutrality. Earlier within section 363A, clause 4, subclause B, minor was defined as a male who is below the age of 16 and female who is below the age of 18 years. Here I'll tell you, it's not that IPC was not amended. IPC has been amended and almost, 73 provisions have been amended in IPC. But then again, these amendments, they were being added in already a colonial affected laws. So it was very difficult. It was creating confusion. Hence, moving to a new criminal law is actually, it's, I'll say, a lot more simplified way is there. So the minor definition, it was added by one of the amendment to the IPC, where the male was below the 16 years and female was below the 18 years. But now, the term child, which has been defined in section 2 of the BNS, that is used so as to maintain the gender neutrality throughout the BNS. Now, wherever the term minor was used in IPC, the minor is also replaced by the term child. Because as I told you, child is any person below the age of 18. Now the present section 141 of BNS, which is about the importation of girl or boy from foreign country. Now this is taken as it is from the IPC 366B. The only difference that has been changed, the positive change which has been brought in is, in 366B IPC, the term used was only girl for the purpose of importation of girl from the foreign country. But to maintain the gender neutrality, the term boy is also added in this section 141 of IPC. Section 143, it gives the definition of trafficking of person. Now, in this trafficking of person, which is again, exploitation, it's an expression of exploitation basically, which includes physical exploitation, sexual exploitation, slavery, or any practices similar to slavery. Here, the term beggary is also used. The child beggars, because it is again a form of exploitation in trafficking. So this is again one of the innovative, I'll say a very progressive change or addition of beggar within the BNS. So anyone who is forcing a child to beg, they will be punished. They will be punished for the year, which may extend to 10 years and shall also be liable for the fine. So it gives emphasis on chapter 5, which was offenses against women and children. Exploitation, trafficking pertaining to children. 370A of IPC, which was about exploitation of a trafficked person. The punishment earlier was 7 years, which is increased to 10 years. The punishment was 5 years, which has increased to 7 years, depending on the act, the nature of the act. Chapter 7. Sedition has been deleted. Now, the sedition was section 124A of IPC. Now, what was the purpose of this sedition? See, we had this Sedition Act of 1870. the sedition law was, this provision, this penal provision was added so as to suppress the independence activist, to suppress the independence movements. So any person who would raise voice against the Queen or the British India, they would be punished under this 124A IPC. Because that was the sole motive of this sedition. So now this has been deleted. Rather, 152, a new provision is added, which says that whoever purposely or knowingly by words, either spoken, written, signed, visible representation by electronic media, or by any financial mean, if excites or attempt to excite, or it encourages the feeling of separatist activity or endangers the sovereignty, unity, and integrity of India, such person will be punished with imprisonment for life, which can extend to 7 years, and shall also be liable to fine. Is it clear? Moreover, see, if there is no major change, sedition was the same thing. But the term sedition has been deleted. Also, the electronic communication, the financial mean, technological advancement, financial frauds that are being done. So it has been added, electronic communication. See, we had this IT Act, right? So the references for the purpose were being taken from this IT Act. But now, since the electronic communication has been added, probably there will be less help taken from the IT Act. Although the definition of document that we have in section 2, it's no more confined to the physical document. It also includes the electronic documents, digital documents. So you can see the shift from the IPC to the BNS. More acquaint with the Indian scenario or indigenous scenario, accounting on the technological digitalization, evolving offenses, they all have been, taken care. Moreover, the colonial term, as in Asiatic power or the power in alliance, government of India under the crown, all these words, they have been replaced. Because they were given in 126 IPC, 124A sedition, which is deleted. They all mentioned about these colonial terms. Chapter 8, Section 159 to Section 168, offenses relating to the Army, Navy, and Armed Force. So this Chapter 8 was actually the Chapter 7 of IPC. Hence, there is no major changes pertaining to this. Okay, it's just that, to maintain the gender neutrality, earlier, the abatement of desertion of soldier, sailor, or airman harboring deserter, this was one given in 524 IPC and 136 IPC, where the term harbor was used twice. So now in the present Chapter 8, it's pertaining to the deletion of, colonial terminologies. Gender neutrality is maintained because earlier it was the male or the husband is the deserter, and now it says the spouse of the deserter. Punishments have increased, where the punishment for deserter on board merchant vessel through the negligence of the master, where the punishment was 500 within 137 IPC, has increased to 3,000, where the punishment was 1 year, it has increased to 2 years. And if any person, soldier, sailor, airman, army, navy, or air service within the government of India, if they wear or carries any token resembling the identity of such person, and if any person who personates it as if they are the from the army, naval, or air person, air service, then on such deception they will be punished for the term of 2,000 rupees and for the period of 3 months. Now, this was also there in 140 IPC, and it has been taken as it is in this chapter 8 under 168. Chapter 9, section 169 to section 177. Now, this chapter 9 was chapter 9A of the IPC. Now, very minor changes pertaining to the increase in the fine, where the fine was 500 within section 177, 171H of IPC. The punishment has increased to 10,000 if there is illegal payment in connection with the election. Now here, wherever, whoever is used, any person is used, then it means the election commission. Because election commission, they are responsible for fair elections in our country. So wherever any person is used, and if such person is indulged in any illegal payment in connection with the elections or failure to keep the election accounts properly, then they will be held for the punishment which can exceed to the 10,000 rupees fine, or it can extend to, depending on the failure, it can extend to 5,000 rupees as well. So minor change where there's increase in punishment and fine within the election offenses, as it is the duty of the election commission to, maintain the this account, and there should not be any illegal payment pertaining to the connection with the elections. Chapter 10. Offenses related to coins and currency. See, this coins and currency in this chapter, actually chapter 10 is a compilation of chapter 18 and chapter 12 of IPC. Now both the chapters are clubbed together into chapter 10. Now the reason of this clubbing is definition or the understanding of coin and Indian coin. Because the coin that were used during colonial time, they should not be counterfeited. So when we talk about chapter 10, we majorly look into or talk about the coin, currency, banknote, and government stamp. Now coin, Indian coin and coin, they were separately defined in IPC. However, in BNS, the definition of coin is as the definition of coin given in section 2 of the Coinage Act. So it is the same definition. The illustration pertaining to what is not the coin is taken as it is from the IPC. Terms like, Her Majesty, any foreign country, they have been removed. Who can issue the stamp was given in 263A of IPC. So it has the same thing. What is the, a change, or rather it's a good change, is the possession of any forged or counterfeit coin, stamp, currency note, or banknote. See, earlier, even if a person who was in possession of such counterfeited currency note, he was held for the offense of counterfeiting coin. Whether the such person is aware whether he is having it or not was not relevant. So any person who was having it, he was held for counterfeiting of coin. But this new addition, it says that if any person who is in possession of a counterfeit coin, okay, but he is not aware of it, or he does not have a reasons to believe that such coin are forged or such coin are counterfeited, then he will not be punished. But if he is aware that it is forged, it is counterfeited, and then he wants to use it for the benefit, then he will be punished for the year, 7 years, or fine, or both. So what change is there? That possession of the counterfeit coin, possession of the forged, currency, it is not an offense. Offense is knowing that it is forged and using it for your benefit. That is forged. That is punishable. Is it clear? Now this burden, the burden on proof to establish whether the possession of, forged currency note coin is on the person who is in possession of it. And if he establishes that such possession of the counterfeit currency, forged stamp, is through a lawful source, then it will not amount to the offense. Is it clear? So mere possession is no more an offense. But then yes, the burden of proof will lie on the person who is in possession of such coin to establish that it is from a lawful source and he was not in the intention to gain any benefit out of it. Is it clear? Any doubt, please tell me. We'll discuss any doubts, any queries at the end of the session. Okay. I'll take up the questions. Don't worry about it. Offenses against public tranquility. Often when we used to discuss about the public tranquility, the three things that used to come to our mind is unlawful assembly, rioting, and affray. So IPC chapter 8 had sections 141 and henceforth, which was about offenses against public tranquility. If there is any incite of violence, if there is any destruction of public property, then it will amount to the tranquility. There is this section 153 double A. Now this section was there in the IPC as well. Okay, but this section was never enforced. So this section has not been taken into BNS. Because there was no use of this, because even being in a IPC, it was not used even single time. So section 189, which is pertaining to 141 IPC about unlawful assembly. And various sections 142, 143, 144, 145, 146, they have been clubbed together in section 189 of the BNS, which talks about unlawful assembly. The punishment for a right has increased to 5 years or with fine or with both. Now this is, what is good about the BNS is all the, offenses pertaining to the similar nature, they have been clubbed in one chapter. So it's very simplified. It has become very easy. Although, the judiciary or the legal fraternity, they are showing their disagreement to this, because IPC, it was more than 160 years it was in practice. But then again, BNS somehow I feel is very simplified. It's if you go through it, it's very easy to understand. The increase in punishment is there from 156, 154. The punishment has now increased to 25,000. Punishments have increased 3 times or 4 times of what it was there in IPC. The new addition is Section 195, Clause 2, which says that whoever threatens to assault, it's about assaulting or obstructing public servant when suppressing the right. So Clause 2 says that whoever threatens to assault or attempt to obstruct any public servant, or threatens or attempts to use criminal force to a public servant, and such public servant is endeavoring to disperse an unlawful assembly or riot or affray, then he will be imprisoned for a term which can extend to 1 year, or with fine, or with both. So it says that threaten to assault, attempt to obstruct, attempt to use criminal force to any public servant when he is discharging his duty to disperse unlawful assembly, suppress riot, or affray. Amputation, assertion, prejudicial in national integration. A new clause, 197, Clause 1, Subclause D. So any person, whoever, by words either spoken or written or sign, or by visible representation or through electronic communication or otherwise, Clause D, makes or publishes false or misleading information, jeopardizing the sovereignty, unity, integrity, or security of a country, he shall be imprisoned, which may extend to 3 years, or with fine, or with both. So whichever is jeopardizing the sovereignty, unity, and integrity, security of a country, then such person will be imprisoned with the punishment of 3 years, or with fine, or with both. Chapter 12, Offenses by or relating to public servants. See, we all are aware that, we have legislature, we have executive, we have judiciary. Now, these 3 bodies, they have their own, nature of work. Legislatures, they make law; executive, they implement it; and judiciary sees the constitutionality of such law. But then, there are chances where the executive can indulge in offense, as in pertaining to the abuse of power or the misuse of the power. So this needs to be taken care. There must be a deterrent provision so that these public servants, they do not erode with the public sentiments, with the public confidence. So these public servants, 102, it was there also. What has been changed is, what has been added is, is the community service. Now, whoever who is a public servant, they are not to engage in any form of trade. They are to perform their duty. They are not to be engaged in any kind of trade apart from their duty. And if anybody who is practicing it, he will be punished with simple imprisonment for a term which may extend to 1 year, with fine or with both, or with community service. So this trading by the public servant, it can also be punished by the community service. Section 204. Now, this section 204 was present there in 170 IPC as well. Now, it says that any person, whoever, he pretends to hold any particular office as of a public servant, or such person personates falsely that he is holding such office, and in such pretension, if does or commits any act under the color of such office, under the false impression that he is holding the office, then he will be liable for the punishment which is not less than 6 months, which can extend to 3 years, and with fine. Is it clear? So the purpose of increasing the fine is to create the deterrence among the convict. So if we just try to understand the new criminal law, there is reform to reform the offender as well to create the deterrence. Now, this reform to offender, this is for the first time offenders. This is not for the repeated offenders. So the first time offender, community service, so that the person does not become a habitual criminal. And deterrence is for the habitual criminals. So accused-oriented punishments have become very stringent, so that to create that deterrence. Okay, so this is from chapter 6 to chapter 12. And if you have any question, you can just, let me know. Any query, any question?
Good afternoon, ma'am.
Yes, good afternoon.
I don't have any doubts. I want to study more about this. Later,
Okay.
I will ask you the doubts.
Okay.
This is my first class. Yesterday, I'm not able to attend the class yesterday.
Okay. So tomorrow again, I'm taking the seminar, and this is about the chapters 13 to chapter 20.
Okay, ma'am. I will
Yeah.
attend.
So, and it's in evening. It's in evening, 7 p.m. onwards. So join
7
that also.
At what time, ma'am?
7 p.m.
7 p.m. 7 to?
7 to 8:30.
Okay, ma'am. Thank you.
Okay. And do give me your feedback. Okay. In case I need to improve, I'll try my best to improve in that particular area.
Okay, ma'am. Thank you.
Okay then. Okay. Take care.